Hi, my name is Madelaine Setiawan, and my paper presentation today is titled, I Know It When I See It, the Supreme Court's Pursuit in Defining Obscenity. The Supreme Court's definition of obscenity, even with many of the landmark decisions, remains somewhat ambiguous. The 1800s unfolded the first obscenity cases in the nation brought before the judiciary. The cases concerned materials believed to violate society's values on propriety and morality. The Supreme Court's pursuit in defining obscenity uncovered a series of legal tests to serve as guidelines for the community and lower courts. Still, the establishment of legal tests did not guarantee a strict definition. The last of these legal tests established by the judicial branch, the Miller test, is still subjective and ambiguous. Since settling with the Miller test, the Supreme Court has not established any other national standards. Justice Stewart reflected the court's attitude in his dissent for Jacob Ellis v. Ohio, stating his famous line, I know it when I see it, suggesting the existing struggle in the court to define legal parameters as one definition of obscenity cannot be effectively be applied to every case, nor can it stand the test of time. The evolution of societal values throughout the years between the 1800s and the 1900s created this difficulty that challenged the Supreme Court's consistency. The 1960s introduced a sexual revolution, which triggered a reaction from the courts in a crucial attempt to meet the demands of society's evolving values on morality. The cases brought before the judiciary consistently reflected the change in societal values, such as prior to the sexual revolution, the court, always in concurrence with society, deemed the challenge materials brought before them as obscene. Following the sexual revolution, as society became more accepting, the court deemed many of the challenge materials not obscene. Today, my thesis is the concern within the spread of obscenity cases between the 1800s and 1900s evolved accordingly to society's values on morality. Thus, due to the change in attitude and behavior, especially the growing acceptance of sensuality among Americans, the Supreme Court had to adapt their definition of obscenity in parallel to the demands of society. The first case that emerged in the Supreme Court on obscenity was Rosen v. United States. Because the court had not established any definition on obscenity, they had to adopt the Hecklin test from an English case called Regina v. Hecklin. The Hecklin test defines obscenity as whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences, and into whose hands a publication of this sort may fall. In Rosen v. United States, the court ruled that publications containing indecency or immorality cannot be mailed. Later, a case called United States v. One book called Ulysses challenged its standing. One of the first landmark decisions by the Supreme Court is in Roth v. United States. Here, Roth sold books and magazines for his business in New York and was later charged for mailing obscene materials. The Supreme Court redefined obscenity here as whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interest. Roth demonstrated a change in the court's definition of obscenity. Previously, anyone could have been charged if there is a likelihood of a corrupt mind. Roth also established that sex and obscenity are not synonymous. According to the court, obscene materials deals with sex in a manner appealing to prurient interest. It is therefore vital that the standards for judging obscenity safeguard the protection of freedom of speech and press for material which does not treat sex in a manner appealing to prurient interest. In Roth v. United States, the court established three reasons why obscenity is not protected under the First Amendment. The first one is the government has a significant interest in protecting minors and unwilling passerby to be exposed to obscene materials. The second one is the government has interest in protecting and preserving societal mores and values. The third one is obscenity lacks any redeeming social importance. In Jacob Ellis v. Ohio, Jacob Ellis was the manager of a motion picture theater who was convicted for playing a movie that the state deemed as obscene. Jacob Ellis v. Ohio was brought to the court in the 1960s during the start of the sexual revolution. The Supreme Court reaffirmed Roth by ruling that the movie is not obscene because it has social value. Justice Stewart's concurring opinion here says, I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that. The next case I would like to talk about is Stanley v. Georgia. Here, federal and state agents searched Stanley's home due to suspicious bookmaking activities. They found film reels which were obscene instead of suspicious activities. The question that the Supreme Court dealt with is if the state can protect the body of a citizen, may it not, argues Georgia, protect his mind. The court has now distinguished that the personal privacy is fundamental to a free society. Justice Marshall's interpretation of the First Amendment brought to light that if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. Our whole constitutional heritage revolves at the thought of giving government the power to control men's minds. In Miller v. California, the court established that obscenity cannot be held to a uniform national standard. In the Miller test, even if a work contains graphic, offensive scenes, if it is followed by a poetry reading or recitation of something moral, it is not obscene, as the value of the entire work is to be judged. The Miller test also showed that the government has significantly reduced prohibition since the Hickman test. Miller also redefined the scope of the First Amendment privilege by allowing the materials that would once be deemed obscene as no longer obscene. The Miller test replaced the requirement of utterly without redeeming social value with the requirement that the material must be taken as a whole. The next few slides, I would like to talk about the sexual revolution. So in the 1940s and in the 1950s, society's views on sex and sexuality were still very conservative. The beliefs behind the sexual revolution gave rise to a new mindset that provides the explanation to why Supreme Court's ruling after Roth v. United States leaned more liberal. And to summarize how heavily the sexual revolution influenced the court, in Roth v. United States, the court established that the First Amendment does not protect areas of obscenity. In Stanley v. Georgia, the court established that the First Amendment prohibits government's interference in a citizen's private pursuit of obscene materials. In Miller v. California, the court established that the First Amendment protects obscene materials if the work is taken as a whole. Each new case that surfaced in the Supreme Court demonstrated a First Amendment progression. Women's right for a zone of privacy, especially to access to contraceptives, became one of the focal points of the sexual revolution. With the pill, large numbers of college women could embark on careers that involved long-term, upfront time commitments in education and training as physicians, lawyers, veterinarians, managers, and academics, among others. Without the access to contraception, women had no power to regulate pregnancies, and the dream of pursuing a career became limited. The sexual revolution also produced women's activists, such as Margaret Sanger, who says, birth control has always been practiced, beginning with infanticide, which is abhorred, and then by abortion, nearly as bad. Contraception, on the other hand, is harmless. Notwithstanding the fact that the sexual revolution emphasized the need for birth control among women, many historians also argue that what marked the sexual revolution significant was not just the pills, but rather society's new way of thinking about sex. According to a historian, a far more important predictor of the frequency with which people engaged in premarital sex in any era was the degree to which people believed that it was socially acceptable to do so. And in circular fashion, the degree to which people held that belief was itself strongly dependent on the proportion of the people who were engaging in premarital sex. That proportion, in turn, was the result of many forces besides the pill. The advancement in technology undoubtedly impacted societal values on sex, but these technology innovations did not cause a social pushback against the Comstock Act or the social acceptance of premarital and extramarital sex. Beyond the walls of the Supreme Court's jurisdiction on obscenity cases lies a transformation of American values and norms. The ambiguity in defining the parameters of obscenity takes root in a society that is constantly evolving. Rosen v. United States presented a society where public discussion of sex was non existent. The only reasonable decision then for the Supreme Court was to rule the challenged materials brought before them as obscene, while also prohibiting the shipment of these materials. However, by the time Miller v. California emerged before the Supreme Court, the spark of the sexual revolution had gone by for a decade. The focus of the sexual revolution itself ought not to be on birth control pills, though they carried the potential and thus the significance to change the course of a woman's life, but on the fact that society warmed up to the same beliefs that past communities would have deemed obscene, such as during the time of Rosen v. United States. When Rosen v. United States emerged in the court, society was still very conservative, but certainly technological advancement impacted how society approached beliefs and ideas. But the judicial manifestation of liberal ruling solely came from the societal values itself. As society evolved its way of thinking, so did the subject matter within obscenity cases brought before the judiciary. No longer did the Supreme Court take on cases to decide whether the challenged material was obscene. The challenge of the Supreme Court consisted of finding the arguments to which obscene materials had First Amendment protection and why. Since the sexual revolution, the Supreme Court mainly focused on constitutional rights, whether it was First Amendment freedom of expression or zone of privacy for women's abortion. Regardless, societal values dictated the Supreme Court's ruling, creating a subjective definition of obscenity to meet the demands of society. Thank you.